Good morning. My name is DJ Ennis, and welcome to Vote Right for America. In episode 13, I covered executive powers in Article 2 of the U.S. Constitution, which is vested in the President of the United States. I briefly went over how the President is elected, the nature of electors, how some sore loser blue states have foolishly bought into the National Popular Vote Interstate Compact, as well as the duties and responsibilities of the President as spelled out in Article 2, Sections 2 and 3, focusing on the President's responsibility to take care that the laws be faithfully executed. In this episode, I'll cover judicial powers. We'll cover Article 3 of the U.S. Constitution. I'll go over some crucial decisions the U.S. Supreme Court has made in the fairly recent past, both good and bad. Article 3, Section 1 begins with the words, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." So we have a Supreme Court. Any decisions made by that court stands as the final interpretation of the Constitution and law. If there is a law that court finds as unconstitutional, that law is voided. If it was a matter of interpretation of a law, their decision on that matter is final. Certainly, not all cases are heard at the Supreme Court. As the Constitution says, the judicial power is also vested in such inferior courts as the Congress may from time to time ordain and establish. What are these inferior courts? In the federal court system, we have a number of federal district courts scattered throughout the states and territories. We have 12 appellate courts, and we have certain specialty courts with limited subject matter and jurisdiction. Section 1 of Article 3 of the Constitution goes on to say, "The judges, both of the supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office." That means they can't get fired for their decisions and rulings. They can't be removed unless they resign or have violated the law or a major code of conduct. They will be paid, and the amount they're being paid cannot be reduced during the time they serve. That way, they cannot be manipulated by others to rule or decide according to someone else's wishes or be unduly influenced. These judges shall be independent. Section 2 of Article 3 gives a listing of what the judges have control over, what they have power over, and the types of cases they can hear. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between the state or the citizens thereof and foreign states, citizens or subjects. It further states, in all cases affecting ambassadors, other public ministers and consuls, these and those in which the state shall be party, the Supreme Court shall have original jurisdiction. It means if it's a case that affects one of these people or a state, the Supreme Court gets the case right off the bat. And then it continues to say, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations the Congress shall make. People or parties in a case can appeal to the Supreme Court. Please understand something here, though. They have a right to request an appeal to the Supreme Court, but that doesn't mean the court will take up the case. If the court takes the case, they will issue what is called a writ of certiorari, which orders the lower courts to provide the Supreme Court all their documents related to the case. If the Supreme Court refuses to hear the case, then whatever was the latest ruling in a lower court stands. Article 3, Section 2 continues to read, "The trial of all crimes, except the cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, The trial shall be at such a place or places as the Congress may by law have directed. In many cases, a trial by jury is waived by both parties and the judge decides the matter. Otherwise, there will be a jury. Impeachment cases, like that of an impeachment of the President of the United States, the trial is conducted before the U.S. Senate with the Chief Justice of the Supreme Court presiding. Normally, during the impeachment process, all witnesses to an impeachable offense present sworn testimony in the House committee considering impeachments, and that information is presented in the Senate during the trial. It's not customary for witnesses to testify in the impeachment trial in the Senate, contrary to what some people say. Section 3 of Article 3 concludes with the definition of treason and indicating that the United States will not confiscate all properties of the person found guilty of treason, and that the family of the one who committed treason will not be punished by the United States by denying them of inheriting the treason offender's property, as was the practice many countries did during the days the Constitution was written. This is not allowed here in this country. Now, let's take a look at a few Supreme Court cases that made indelible imprints on American lives, both good and bad. Here are some good decisions of the U.S. Supreme Court. Brown versus Board of Education, Topeka. The court reversed its previous separate but equal doctrine established in Plessy versus Ferguson of 1896 when it comes to public education. The Board of Education of Topeka, Kansas operated separate elementary schools for white and black students based on an 1879 law. 13 parents in Topeka challenged this law on behalf of 20 children with the assistance of the NAACP in Topeka. In 1951, each of the families attempted to enroll their children in the school closest to them. These schools were designated for whites. These children were refused admission and were directed to the African American schools located further from where they lived. The court cited the 14th Amendment where it says, "No state shall take or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." District of Columbia versus Heller. The case arose when Dick Heller, a District of Columbia special police officer who was authorized to carry a handgun while on duty at the Thurgood Marshall Judiciary Building, applied for a registration certificate for a handgun that he wished to keep at his home, but was refused by D.C. officials. He filed suit on Second Amendment grounds that he had the right to have a firearm in his home. The case began with the Federal District Court in Washington, D.C., where they ruled against Mr. Heller. He appealed the decision, and the appellate court ruled in his favor. The District of Columbia appealed to the Supreme Court. This decision was a 5-4 ruling, with wishy-washy Justice Anthony Kennedy becoming the swing vote, joining conservative court members Justices Scalia, who wrote the opinion of the court, Chief Justice Roberts, Justice Thomas, and Justice Alito. The court affirmed that individuals had the right to own firearms, even if they were not directly connected to a militia. Horn versus Department of Agriculture. Marvin and Laura Horn refused to set aside a portion of their raisin crop on the ground that the reserve requirement in an old FDR-era law, the Agricultural Marketing Agreement Act of 1937, was an unconstitutional taking of their property for public use without just compensation. The act required that raisin growers were to reserve a certain percentage of their crop to be taken by the Department of Agriculture to be sold in non-competitive markets, donated or disposed of, and then consistent with the purposes of the program, if any profits are left over after subtracting the government's expenses from administering the program, the net proceeds were distributed back to the raisin growers. All the justices in the court, except for liberal Justice Sotomayor, agreed with the Horns, pointing out the Fifth Amendment's eminent domain doctrine requires the government pay just compensation when it takes personal property, just like when it takes real property. They overruled the most overruled circuit court in the country, the liberal Ninth Circuit Court of Appeals, in this decision. And now for some bad Supreme Court decisions. Roe v. Wade. I discussed this decision at length in episode 11. It's amazing how they interpreted the 14th Amendment to not recognize a person, such as an unborn person. This was a twisted, narrow-minded decision. Obergefell versus Hodges. This is a case of pandering to a political base. In this badly reasoned 5-4 decision, the majority of the court went berserk in applying the 14th Amendment to this case where James Obergefell and John Arthur wanted to get married before John Arthur succumbed to ALS. They wanted to be married in Maryland, a state that recognized same-sex marriages, but they lived in Ohio, a state that didn't recognize same-sex marriages. The couple couldn't make the trip from Ohio and Maryland easily because of Arthur's health issues. Nevertheless, they traveled and were married in a medical transport plane on Baltimore, Maryland tarmac. Later, when Arthur died in Ohio, the state refused to list Obergefell as a surviving spouse on Arthur's death certificate. He brought suit to be recognized as a surviving spouse on the death certificate, and other same-sex couples filed suit against their respective states to recognize same-sex marriages. What the majority of the court missed was that the purpose of marriage had more to do from a purely legalistic standpoint with the transfer of wealth from one generation to the next. It was from ancient times, even in non-Judeo-Christian societies, that a marriage uniting a man and a woman would most likely yield offspring. The marital law's intent was to provide for legitimate inheritance and even the enjoyment of such an inheritance by the offspring, as evidenced by restrictions in marital laws that closely related people couldn't marry because any offspring may be hampered mentally and physically from undesirable genetic problems. Also, marital laws preempts making a mockery of marriage by restricting people from marrying inanimate objects and non-humans. The left is absorbed by feelings on this issue enough to create a right of marriage. Marriage is not a right. If it were so, why do we need a license from the state? Chief Justice Roberts said it best in his dissenting opinion. The majority's decision is an act of will, not legal judgment. The right it announces has no basis in the Constitution or this court's precedent. He further noted, the majority today neglects the restrained conception of the judicial role. It seizes for itself a question the Constitution leaves to the people, at a time when the people are engaged in a vibrant debate on that question. And it answers that question based not on neutral principles of constitutional law, but on its own understanding of what freedom is and must become. Chief Justice Roberts concluded his dissenting opinion with, if you are among the many Americans of whatever sexual orientation who favor expanding same-sex marriage, by all means, celebrate today's decision. Celebrate the achievement of a desired goal. Celebrate the opportunity for a new expression of commitment to a partner. Celebrate the availability of new benefits, but do not celebrate the Constitution. It had nothing to do with it. Another bad decision is Kelo versus City of New London. Suzette Kelo and others who lived in Fort Trumbull area of New London, Connecticut, were notified that their properties were being condemned, not because they were blighted, but because they were in an economic development zone. The city was planning to take their properties and hand them over to a private developer with the hopes of developing a shopping mall. Supposedly, the shopping mall would bring a lot of sales tax revenues for the city. The court, with all 4 liberal justices, joined by wishy-washy Justice Kennedy, wrongly decided for the government. Their petty thinking was that government can create economies, that ridiculous element of the egalitarian political economic philosophy. The doctrine of eminent domain was for public purposes, not private enjoyment. Sadly, Mrs. Kelo and her neighbors lost their properties. The properties were bulldozed over, the mall was never built, and the private developer couldn't obtain financing for the project. These bad Supreme Court rulings made it abundantly clear that we should have good originalist conservative judges and justices on our courts, especially the Supreme Court. And the only way we can have those kind of judges and justices is to vote in presidents and senators who are also conservative. That means no voting for Democrats, socialists, or communists, because they'll make up stuff that's not really in the Constitution, stuff that brings on bad, intrusive government. You're watching Vote Right for America. Please subscribe to this vlog. It's free. And you can also email me with your comments and questions at vrfa.djennis@gmail.com. And please comment. I'll use your comments and questions to clear up matters or concerns you have in future episodes. Good day.